Okay, well, welcome to the webinar today on COVID-19 in your workplace rights. Raise your hand if you are concerned about your employment rights in the age of COVID-19. Yeah, it's okay. You can raise your hand by yourself in the room or with your kids beside you, which is probably what a lot of us are doing while we're trying to work from home. Raise your hand if you spent a lot of time investing in your career and want to make sure that you protect your job, right? An easy one. Well, I want to congratulate you on being in the right place and on taking some time to learn about your workplace rights in COVID-19. There have been more changes in a short period of time than I have seen in the entire time that I have been practicing employment law. The churn is just incredible, and every day almost we're seeing something new come down. Some of them are temporary changes, some of them are probably going to be permanent, but all of them are important to the workplace and to you. My name is Tom Spiggle. I'm founder of the Spiggle Law Firm. If it's all right, I'll share a little bit just briefly about myself and about why we do this. I started this firm back in 2009 because I knew that employees needed advice on what was a very complicated area of law. Very good lawyers who don't do this all the time don't know the ins and outs. So you can't expect even an educated person who's not a lawyer to understand it unless they have advice. And so that's why I started the firm. We've got a number of lawyers now, all very experienced, and this is what we do all day long. And I'm excited to share some of this information with you because I'll tell you who is also following this, your employer. So they're talking to their lawyer, they are learning these ins and outs. And the thing about employment law is that a lot of times it's not very intuitive. So there are all kinds of ins and outs and weird tripwires that if you're not aware of them, it can really affect your career. And so I want to congratulate you again on being here to learn some of these today. And of course, we're not going to be able to cover all of them. There are a lot of resources in these slides, and I encourage you to use this as a resource as you continue to explore this area. And then for my one area of I'm a lawyer, so I got to do the legalese, right? Like this is not legal advice for your case. Obviously, I don't know who you are and what the specific facts are of your matter. So if you have specific questions, you got it, you should go see a lawyer. I include a link in the end. We'll talk about a little bit more in a bit, but I will say there are some really great websites. I mean, you can, of course, call us at 202-449-8527. If you go to our website, we also have a contact us link at the top right, which you can use. If you're in the DC area, there's a great website called MWELA, MWELA.org, which are lawyers in the DMV area who focus on employee rights. If you're outside of the DMV area, another great website is NELA, NELA.org. It's the National Organization for Employee Side Attorneys, and it has attorney locator functions, great way to find an attorney. Another great resource, AVVO, AVVO.com. It's not explicitly for employment lawyers, but it does allow you to search by employment law. Another great resource if you need specific advice about your case. So let's get started. What I want you to get out of the webinar today, we're going to go about half an hour, maybe about 45 minutes. I want you to understand what your safety rights are in the workplace. I want you to understand what your rights are if you have some kind of pre-existing condition that makes you particularly susceptible to being to COVID-19 or to having a really serious case of it. I want you to understand what your whistleblower rights are. And at the end, we're going to talk about how you think like a lawyer does when trying to approach your employer about some of these issues. So this is a little bit about me, about the book that I wrote, You're Pregnant, You're Fired. And we took a lot of pictures to try to get that one. So we're glad we got a good picture there. So what the first thing is, know the law and where to find it. As we talked about, the law in this area is very complicated, so you're not going to know it, of course, off the top of your head, but it's important that you know where to find it. And we're going to talk about that today. Some websites that you can go to, some resources that you can use to have these sorts of things at your fingertips, because we're going to get into some detail today that, of course, you're not going to, nor do I expect you to be able to remember, particularly when you're in the thick of it. So the important part is that you at least know what categories of law are out there and where to find them. And we're going to be talking about that during this presentation. Know the key leverage points, and we're going to talk about this some more at the end, but it's not just about knowing the law, it's about knowing what leverage it provides you to get the workplace changes that you need. Not all laws are created equal. For example, some of the laws that we'll talk about today don't have what's called a private right of action, which basically means you don't have an individual protection under that law such that if you wanted to, you could go off to court and sue. And I know that's not the objective of most of the folks on this webinar, but that's how employers look at it, right? Like when these are raised with an employer, they're looking at what's my exposure, what would happen if this law is violated, and if the employee can go to court and sue for money damages and other sorts of damages, then that's something that's going to give you more leverage. Also, how you approach your employer can affect what leverage that you have. It's not just the law itself, but how you raise the issue with your employer and what your objective is in doing so. Is it just to get a workplace change? Is it to try to get a severance? Is it just to protect your job and keep things as they are? All of those can play into how you approach it. We'll talk about that some more at the end. But when we're going through this, I want you to be thinking, not all these laws are created equal. So just because I raise one of them doesn't mean it is, it has the same kind of teeth as other laws. And we'll be talking about that when we go through some of these points today. As a threshold matter, I want to address some of the questions that we often get, just generally related to COVID-19. And one is, can your employer require you to come back to work? With some significant exceptions, particularly if you have pre-existing conditions, which we're going to get to in a minute when we talk about the Americans with Disabilities Act, the general answer is yes. If you don't have some reason that keeps you out of work, then your employer can require you to come back. And the fact that you may be really justifiably worried about coming back to work and being exposed to COVID is not a reason to stay out of work. So if you refuse, in many instances, your employer can legally fire you. So it's important that you, rather than just saying no, or just talking about, your fear of being exposed, that you have more of a dialogue. And then, of course, if you do have a health condition that makes you particularly susceptible to having a really bad case of COVID, to being negatively affected by it, then you want to raise that with your employer, and we'll talk about that in a minute. There are a couple of things your employer can also do. And this is a developing area of the law. Generally, your employer is limited in the kind of questions they can ask you about your health. And a great resource for this is if you go to the EEOC, the Equal Employment Opportunity Commission, which is the government agency responsible for enforcing a lot of these laws, not all of them, but a lot of them. And they have an FAQ page, and you can find it at eeoc.gov. A lot of great information there, and they have an FAQ page, and they talk about employers' rights under the Americans with Disabilities Act, which the EEOC enforces. And they note that in a time of a pandemic like this, your employer does have the right to ask you some questions about exposure to COVID. They can do things like take your temperature, again, which pre-COVID, this is not something your employer could do, but during a pandemic, they are entitled to protect their workplace, and they are entitled to do some of these things. There's still a line that they cannot cross. They're not entitled to ask you specifically, questions that would raise other issues about your health, about your disability status. You can, of course, share that with your employer, and as we'll discuss in a minute, you may want to do that, but your employer can't ask about this. But your employer can ask general questions about, You know, have you had a fever? They can take your temperature. They can ask you about your exposure, potential exposure to COVID. So look at the EEOC. It's got some great resources for employers. It's important for employees to know that. So if you have a question, you know, can my employer do this? The EEOC is a good place to go. You know, AVO is another good place to go where you can post these questions, and you can, of course, you know, as always, contact a lawyer. All right, so let's talk about safety in the workplace and the laws that govern that. And generally, what you'll find is we're talking about the Occupational Safety and Health Administration, or OSHA. So that's the federal administration. It's under the Department of Labor. And then there are state equivalents, and they generally are the ones that are passing regulations about workplace safety. So here is the website. And again, you'll be getting these slides, and you can use this link to OSHA and their FAQ page about safety in the workplace. I will say that OSHA is it's not the first place that I would turn to get help individually. It's important for you to know these kind of guidance that OSHA has promulgated. You know, not to make this is not a political webinar, but I will say under the Trump administration, you know, OSHA has been not very active. So a lot of what they are posting is just guidance. It doesn't have the force of law. Nevertheless, it can be helpful to know what OSHA is saying about workplace regulations, and this FAQ page can be a good place to start to get a sense of what they're talking about, because they are providing some guidance about how employers should conduct themselves during the time of COVID and what they need to know to protect employees against a known risk. But when we talk about leverage, a lot of what you'll see on this website does not have the force of law, and it doesn't have, in many cases, a private right of action. So if your employer isn't, you know, dotting their I's and crossing their T's according to the regulations or the guidance posted on OSHA, it's not something, in many cases, you can turn around and say, aha, this has been a violation. My employer has violated the law. And even if that has happened, contacting OSHA and filing a claim, which you can do, you know, I wouldn't hold your breath waiting for OSHA to write in and to help you. There can still be reasons to do it, and we're going to talk about this in a minute in terms of whistleblower protection and giving you some protection at your job, but expecting OSHA to do much to help an individual is rare. That's not to say you can't explore that option, but when we talk about leverage, OSHA itself is generally not it. Nevertheless, a good source of information to see what the federal government is doing. I will say also, on the website, they will talk about what states are doing and what state level OSHAs that are called different things in different states are doing. And so it can be a good resource, you know, for you to go, and if you want to see what your state is doing and you're having trouble finding the state equivalent of OSHA, you can find it on this website. Now, Virginia, if you're in Virginia, you're lucky, because Virginia is one of the first states to act broad workplace protections under COVID. And I published a Forbes article here. You'll see the link to it that'll break down what kind of protections Virginia is providing. For the moment, these are limited protections. They're set to sunset within 6 months, but they are in effect now. They're fairly complicated. I would urge you to look at this article, but if you'll note, if you look at the article or if you go to the Virginia site, that they break the workplaces down into categories. So there's high risk, medium risk, low risk. For most office workers, you are going to be in the low risk category. So, you know, your employer will have limited obligations to provide you with things like PPE, you know, as opposed to people who are in a high risk category. You know, if you're a healthcare worker, or if you are working in a nursing home where the employer has many more regulations that they must follow to ensure workplace safety. But it's worth looking into. If your employer has over 11 employees, and is in a medium risk category or above, then it has to produce a report that you can ask for. So that may be something that if you have questions about what is going on in your specific workplace, you can talk to your employer about. So again, if you're in Virginia, much broader protections than under the federal side, certainly. If you're outside of Virginia, again, you want to check with your state level, or if you're in DC, the district level, the equivalent of the Occupational Safety and Health Administration office. You can find it on the main webpage, or just, we can go to Dr. Google or Lawyer Google and type in, occupational safety and health, your state, and it will usually pull it up, because your state, it depends, but your state may have more protections than what the federal government is providing. And one key thing to look for, again, when we talk about leverage, is there a private right of action? What happens if your employer violates this law or doesn't follow this regulation? Is there a there there? Can you go and sue for that? Are there civil penalties? Who reports? So it's not just what the law says, but what is the consequence if the employer violates it? Whistleblower protections. Now, this is a big deal, again, if you are in Virginia. So, let me back up and say whistleblower protections generally are a big deal. You'll look under the federal law there, you'll see in the slides, Section 11C provides whistleblower protection. Virginia has a new law that was passed in July. I've got a link to an article that I wrote about it here. The law is HB 7998. The important thing to know about both of these laws is that it is illegal for an employer to take action against you because you report a safety violation. And what constitutes a report varies a bit under the law, but certainly if under OSHA, if you file something with OSHA, if you contact OSHA, if again you raise it with the Virginia equivalent and file something or call them, certainly if you participate, there's an ongoing investigation. Let's say you didn't call them, but you participate, and your employer takes an action against you. But it can be firing certainly, but also a demotion, any other negative workplace action against you because you filed with OSHA or because you participated in an investigation. That can be a violation of the whistleblower sections. There is some there to these laws, and by that I mean you can go to court for a violation and receive what are called damages, money damages, right? So if you get fired and you get lost wages, the money that you would have made had you not been fired, you're eligible to get those lost wages. In some cases, you can get punitive damages, which are damages designed to punish an employer. In some cases, you could also get your attorney's fees paid for. So while OSHA itself doesn't provide much protection. So if your employer is, you think it's violating an OSHA provision, you contact them. I wouldn't say there's no chance, but the chances are slim that OSHA is going to write in and force your employer to correct the problem. It might. But if you make that report, regardless of what OSHA does with it, and your employer takes action against you, then that could be a violation of these whistleblower provisions. I would really, if you are, you've experienced some of this is the area where I would definitely suggest that you contact a lawyer, because it can be very tricky to navigate these waters. And at the very least, you should know your rights. So that's some good news for employees about protection, particularly in Virginia. Privacy considerations. Now, this is something, where employers are asking you to share certain health information. For instance, what happens if you contract COVID and you tell your employer, or when we get a little bit further in and we're talking about where you're sharing with your employer information about your underlying conditions, what protections are there? There are two broad federal laws that provide some protection. One is the Health Insurance Portability Act, or HIPAA, and then there's the Americans with Disabilities Act. Now, HIPAA, and we've all seen this, you sign the releases when you go to your doctor to release certain medical information. It's a broad law. It does provide some protection. There is no private right of action generally under HIPAA. So if your employer violates it, and first, they may not even be covered by HIPAA, depending on who your employer is. It often just applies to medical professionals, but it's not something that you can usually, run off to court and receive some damages for. But nevertheless, companies can be penalized for it. So it's something to be, if you think that your privacy rights are being violated, if you have questions about that, you might want to look up HIPAA. All right, so Americans Disabilities Act is the other one. If you have an underlying condition and you share that with your employer under the act has to keep that information private. There are some private rights of action for your employer if they share that information. So again, if you have an underlying condition, you share that with your employer and your employer fails to keep that private, there may be some things that you can do there. So now let's get specifically to ADA protections, or the Americans with Disabilities Act. Again, provides broad protections for employees who have underlying conditions. So the ADA broadly protects people with a disability. Now, disability is very broadly defined under the Act. So it doesn't have to be a permanent disability. It can be, for example, like postpartum depression, generalized anxiety disorder, other forms of depression. So it can be mental, and it can be limited. So it doesn't have to be a lifelong disability for you to be covered by the Act. It's enforced by the EEOC. So as we talked about earlier, you can find that at the eeoc.gov. If you believe that if your rights have been violated under the ADA, it's important to know that you have a limited amount of time to raise those. You have to file, depending on the state, either 180 days or 300 days. You have to file something called a charge with the EEOC in order to protect your rights. So I don't care how strong your case is, if you don't file with the EEOC, then you're going to lose your rights. So be aware of the time frame. So what does that protection look like? Let's say, for instance, that you have multiple sclerosis, which is a disability that's definitely protected by the ADA. If you share that with your employer, and this is an important thing to understand, your employer is prevented in many instances from asking you about these conditions. So you have to share it with your employer, or you may not be protected, right? So if you have something, if you have a flare-up in your multiple sclerosis and it's affecting you, what you're doing at work, and your employer is not on notice that you have MS, and they take some action against you, then you may not be protected by the ADA. So if you have an underlying condition, it's important that you share that with your employer, share that with HR, so they are on notice, because what does the ADA provide? It prevents an employer from discriminating against you, right? So you're not asking for any workplace changes. You're just letting them know that you have a disability. Your employer can't take action because of that. More importantly, the ADA requires the employer in many instances to provide you an accommodation, a workplace change, if you need one to address an underlying condition that you have. Now, you don't have a right to get exactly what you asked for, but the employer has to engage in what's called the interactive process with you. So, for instance, if you have a respiratory illness, something that makes you particularly susceptible to perhaps a fatal run-in with COVID-19, then you could ask for telework, for instance, and that's an accommodation. And your employer has to engage in an interactive process with you. They can't just say no. They have to talk with you about that, the possibility of providing that kind of accommodation. So this is an area where, again, we talked earlier, generally employers can require you to come back to work, but if you have a disability that could potentially put you at significant risk if you return to work, then that's an area where you may have some rights to ask for a workplace change, including being out for work for a time, teleworking. Now obviously office workplace culture has changed. Telework and working from home has become where many of us are doing it now. It's much more difficult for employers to say, hey, we can't allow telework because that won't work for our organization, because workplaces are having to make it work. That's going to be an option, a real option for a lot of people. And if your employer declines to allow you to do that, without good reason under the ADA, then that may be a violation of that act, and you should consider filing a charge. At the very least, you should talk to an attorney about that to help you interact with your employer to try to get that leave. So an important thing to consider. I'm going to add here, it's not under the Americans with Disabilities Act, but well, let me say this. An employer also cannot, for paternalistic reasons, here we go, paternalistic reasons also force you to stay at home. So let's suppose that you have an underlying condition and you want to come back in for whatever reason, even though it is a danger to you. An employer can't say, you know what, we are not going to allow you to do that because you have this disability, and so we're going to force you to act in this different way. An employer can't, for paternalistic reasons, do that. A different law, but worth raising here, also for those of us who are over 40 and are protected by the Age Discrimination in Employment Act, ADEA. Obviously COVID has different effects for those who are over 40 than for those that are under. Again, just because you are older and perhaps more susceptible to COVID is generally not a reason to decline to come back to work. But similarly, an employer cannot force you to stay at home or change your job because even if out of the goodness of its heart, the employer is making workplace changes to try to protect you, even though you want to work as normal. I will say under both the ADA and under the ADEA, which is the Age Discrimination in Employment Act, your employer can take actions against you, get rid of you, fire you, demote you because you're older, because you're disabled, and because the employer is concerned about its liability under COVID. That would be a discriminatory reason to take those actions. And both the ADA and the ADEA have private rights of action. So again, there's some there if an employer violates those laws. I will note that we'll see how this shakes out, but COVID is showing signs in some people of having very long-term effects, GI effects, respiratory illness. So it very well could be that while having COVID a limited amount of time may not mean you are protected by ADA. If you have these long-term effects, then you could be. You could be covered by the Americans with Disabilities Act. So something to keep in mind for those of you who do contract it, and then you have these long-term effects which affect your ability to work. Let's talk a little bit about discrimination. In addition to, discrimination on the basis of age, we just talked about discrimination on the basis of disability. There's just plain old discrimination that we are seeing occurring because of COVID, particularly for those of Asian American heritage. We are sadly seeing some of that discrimination in the workplace where, say, assume you got the Asian flu, and so, we're going to take these actions against you, and we're going to take these actions against you because of your heritage. Or, it's not your employer, but perhaps you are experiencing a hostile work environment. You've got those in management, perhaps just other coworkers who are making derogatory remarks about you because of your heritage, because of your race, because of your disability, because of your age. I mean, these are all protected under anti-discrimination laws. For example, if it's Asian heritage, then under Title VII. If it's, because of your disability, it's under the Americans with Disabilities Act. If it's because of your age, so because under the Age Discrimination in Employment Act, these are all enforced by the EEOC. So EEOC is a great resource to use for information about those. And as for all of those laws, in order to protect your rights, you do have to file a charge with the agency within 180 to 300 days in order to protect those rights. Filing a charge is not particularly difficult. You don't have to be a lawyer to do it. It helps to have a lawyer, but you don't have to be one. If you go to the EEOC, they've got a lot of good information on their website about how to file a charge. All right, so how to stick it to them like a lawyer if you're having some of these problems. Let's talk about some of the things you need to think about. First is understand your objective. What is it that you are trying to do? Is it that you are just trying to keep your workplace safe? You want to keep your job? You just want to keep things even keel? Well, then you don't want to, in that situation, come in guns blazing, talking about how your employer is violating the law, because that's often not going to get a favorable response. And if they think that you're going to be litigious, it can put your employer back into a corner. There's a little bit of judgment about how you do this. And sometimes it may just be ignorance on the part of your employer. As I mentioned, there's a lot of churn in employment law, a lot of things that are taking place. Your employer just may not know some of these new changes. So it could be just a matter of bringing it to their attention. I would suggest that you do that in writing, whether it's in, an email is good, text or whatever it is that you may be using. Share it to them in writing. Know your audience. Who are you talking to? Are you talking to, someone who in HR, who does this all day long, who can be expected to know some of these things? Then you might talk to them in a more cut and dry sort of way about what the law is or what your understanding of the law is. If it's your direct line supervisor, again, you maybe want to have a little more finesse there and make it clear that, hey, I'm not here to be a skunk at the Christmas party. I'm just trying to make sure we're all protected. I just want to make sure that you are aware of this and share it with your direct supervisor. Again, if you don't see any action there, you might want to take it to HR. Again, doing it in a way that is not suggesting that you're going to sue. You're here to play ball. You're trying to make the workplace safe. You want to have a conversation about this. If you're not getting the results that you want from that, then you may want to try to get to the employer's attorney, which can be difficult depending on the size of the employer. If it's a large employer, you may want to try to get to in-house counsel. If it's a smaller employer, they may have an outside attorney. And then again, also for larger employers, they'll have what's called specialized outside counsel, often for employment law. So if you're having one of these issues, you address it up the line and you're not getting the response that you need, you might want to try to get to the lawyer, the in-house counsel, see if you can find their name and send this information to them. Because the truth is that HR is wearing a lot of hats. They're often very busy. And sometimes they just don't have the juice to make the workplace changes that you need. You can always consider getting a lawyer, because that will definitely get you to inside counsel or outside counsel if you show up with an attorney. Again, that often ups the ante. So you want to think about whether or not that's the way you want to go. Again, thinking about your objective. Is that you just want to stay at your job, or are you planning to leave? And it's about, making the best exit package for yourself. That will affect, when it makes sense to bring in an attorney and how to do it. Make sure you meet your deadline, right? A lot of these laws have very, very short timeframes. We talked about under Title VII and under the ADA. You have anywhere from 180 days to 380 days to file that charge, or you lose those rights forever. Some laws, if you're in the federal government, you have a shorter time frame. It can be up to as short as 45 days. Some of the OSHA provisions, the time frame is as short as 30 days. So you want to make sure that you are within those time frames, because if you plan to take action on it and you're outside of those time frames, you may be out of luck completely, no matter how egregious the violation is. And then, of course, I really may think, coming from a lawyer, this may not be a surprise, but I do think it makes sense, if you're concerned about these, whether you hire a lawyer or not, to schedule a time to talk to one. Just go have a consult. They can at least advise you about their rights. Most attorneys who do this work, like our firm, do this work a lot, know which way the wind is blowing in terms of how to deal with your employer in order to meet your objective. Again, right? Like, it's not about the lawyer making money. It's not about the lawyer running off to court. It's about what you want out of this. Do you just want a workplace change? Do you just want to know what your rights are so you can sleep better at night? Your employer need not ever know you went to see a lawyer. Then, absolutely go have the consult, find out what the law is, get the advice from the attorney, and you decide how you want to proceed. Then, of course, hiring a lawyer to do what lawyers do and to show up and to interact with your employer can often be very effective, and sometimes is the only effective thing if your employer is just not paying attention. Because when a lawyer shows up, they're going to pay attention one way or another. But of course, you need to consider what that might mean for your career prospects at your employer. And again, it's a good idea to get some kind of consult, because lawyers who do this work can give you some idea of what the practical implications are for raising some of these laws. So that's the end of the presentation. If anybody has questions, I haven't seen any, but if anybody has any questions, this would be the time to ask them. If you get done with this webinar and you realize you have questions later, you can always contact our firm. Again, Avo is another great platform to ask these questions, and you can do so without cost there. It looks like we got a question. The question is, I was fired because I was diagnosed with COVID and needed to take time off. What can I do? Great question. I'm sorry that happened to you. There are laws that protect you if you have been diagnosed with COVID. There is the Emergency FMLA Act, which applies to all employers. So EFMLA, it's enforced by the Department of Labor. If you've been diagnosed with COVID, then you are allowed a certain amount of time off and job protection. So I would really suggest that you consult a lawyer about that. There's also the emergency sick leave provision, which gives up to 2 weeks of leave for those who've been diagnosed with COVID. Then there's also just the regular Family Medical Leave Act, which can provide some job protection. It, however, only applies to employers with 50 or more employees. So if your employer has 50 or more employees, then you could be covered by FMLA, and it could be a violation of that if you're fired for having COVID. So I would suggest those two things. Look at the Department of Labor, see if you are covered, your employer is covered under the FMLA. If it was because you personally had COVID, if it was in that first 2 weeks, if your employer violated the emergency sick leave provision under the CARES Act, and then if you have, you need child care, you were fired because you had to provide child care for someone for COVID-related reasons, the school's been shut down, then there's also additional leave protection under the CARES Act. You didn't raise that in your question, but I did want to address that. So again, look at the Department of Labor under the CARES Act, under the emergency sick leave, and under FMLA. And as always, if you think those rights have been violated, that would be a good reason to contact a lawyer. In your slides, you can click and get our download, free download for our guide on how to protect yourself and the workplace in the time of COVID. And then you can always sign up for our newsletter. It's chock full of great information, comes out monthly. We really spend a lot of time curating it and making sure that information is useful and timely for people to protect their jobs, because as I noted when I started here, if you're like me, and I'm sure most of you are, you've spent a lot of time and a lot of money to get where you are in your career. And there's a lot at stake in you keeping your job and your career trajectory. So it makes sense to take a few minutes every month, excuse me, to keep yourself up to speed, because again, your employer is talking to its lawyer. They know the deal, so should you. Thanks for taking the time. I congratulate you on spending a little time to invest in yourself today, and I wish everyone the very best of luck. Take care.